5 seconds to go. Start. Although all these three vital eyewitnesses were subjected to lengthy cross examinations, nothing material could be elicited capable of creating any dent in their evidence with regard to the material fact that both the accused appellants brought down the victim from the bus, picked up a quarrel with him, and assaulted him, thereby causing injuries which resulted in his death. PW10, the doctor who conducted the post-mortem examination, found the following injuries on the person of the victim: one abrasion with contusion measuring 6 cm into 4 cm present on right forearm, ulnar side 6 am above the tip of ulnar stellate process. One lacerated wound measuring 4 cm into 3 cm scalp layers deep on right parietal area of the scalp, which was found on stitches. In the opinion of the doctor, death was caused due to coma resulting from head injuries, and the injuries were ante-mortem and caused by blunt force impact. The doctor stated that the injuries found on the scalp was sufficient to cause death of the person in ordinary course of nature. It was further elicited during cross-examination of the doctor that the injuries found on the scalp of the deceased could be caused by spilt bamboo. The death of the victim because of the injuries sustained on the head caused by blunt object has not been disputed in the present case. The presence of the accused persons at the place of occurrence and involvement in the incident has also not been denied. The accused appellant Rajesh Sahu in his examination under section 313 CRPC admitted that the scooter was parked in front of the bus and there was altercation between the victim and the accused appellant Prakash Chowhan. He also stated in his cross-examination that he, along with other passengers of the bus, intervened and dispersed the accused Prakash Chowhan. Accused Rajesh Sahu further stated in his statement under section 313 CRPC that someone from the bus rebuked Prakash Chowhan by using slang language. He further stated that when Prakash Chowhan was altercating with the victim, he tried to dissuade Prakash Chowhan from quarreling. The accused appellant Prakash Chowhan, while denying the incriminating evidence against him during examination under section 313 CRPC, stated that while he was proceeding in the scooter, some passengers from the bus shouted at him, uttering slang words. He also stated that when the bus stopped at Kendugudi, he had seen Rajesh Sahu altercating with a passenger of the bus. He further stated in his examination under section 313 CRPC that he had seen a stick in the hand of Rajesh Sahu and some people were trying to dissuade him. He also stated that during examination under section 313 CRPC that when a passenger of the bus sustained injury, Rajesh Sahu left the place with the stick in his hand. What therefore transpires from the statement of both the accused persons in their examination under section 313 CRPC is that both the accused appellants during their examination under section 313 CRPC admitted their presence at the place of occurrence and also the factum of the victim being assaulted. However, both the accused persons have been found to have made an attempt to shift the liability of assaulting the victim upon the other. Though the statement of the accused recorded under section 313 CRPC not being on oath is not evidence stricto sensu, the law with regard to the scope of use of the statement of the accused under section 313 CRPC is well settled by catena of authorities of the apex court as well as of this court. The apex court in the case of Sukhdev Singh Supra clearly held that such statement recorded under section 313 CRPC can be used for proving the guilt of the accused and held as under. That brings us to the question whether such a statement recorded under section 313 of the code can constitute the sole basis for conviction. Since no oath is administered to the accused, the statements made by the accused will not be evidence stricto sensu. That is why subsection 3 says that the accused shall not render himself liable to punishment if he gives false answers. Then comes subsection 4, which reads, the answers given by the accused may be taken into consideration in such inquiry or trial and put in evidence for or against him in any other inquiry into or trial for any other offence which such answers may tend to show he has committed. Thus, the answers given by the accused in response to his examination under section 313 can be taken into consideration in such inquiry or trial. This much is clear on a plain reading of the above subsection. Therefore, though not strictly evidence, subsection 4 permits that it may be taken into consideration in the said inquiry or trial. Stop.